Having also found that no merit exists in all the above three consolidated petitions, I join my learned brothers and Mani Jesse in dismissing all the three petitions and abiding by the consequential orders made in the lead judgment.
Dissatisfied with the verdict of the Presidential Election Court on September the 6th, the three appellates, Atiku Abubakar of the People's Democratic Party, Labour Party's Peter Obi, and the Allied People's Movement, filed the appeals urging the Supreme Court to nullify the victory of President Tinubu. In the 42-page notice of appeal filed by 18 senior advocates and 47 lawyers, the former vice president anchored his appeal on 35 grounds. Amongst other things, the PDP candidate held that the lower court erred in law when it refused to uphold as mandatory electronic transmission of results for confirmation and verification of final results as introduced by the Electoral Act 2022 for transparency and integrity of results. In another ground of appeal, the appellants argued that the lower court erred in law when it failed to determine their case with respect to the mandatory verifications and confirmations required before the announcement of the result of the presidential election. They also faulted the lower court for its interpretation of the use of the word and the FCT in relation to Section 134(2)(b) of the 1999 Constitution. The appellants also touched on the issue on the use of what it called disparaging words by the court against Mr. Atiku Abubakar and the PDP, which they termed as indication of bias and which violated the rights of fair hearing and occasioned grave miscarriage of justice. In the final analysis, Mr. Abubakar and his party urged the Supreme Court to set aside the judgment of the Presidential Election Petition Court to declare that President Tinubu is not the winner of the polls, was not even qualified to contest the polls, and to instead declare the PDP candidate as the winner of the polls, or in the alternative to order INEC to conduct a second election between him and President Tinubu. While this was pending before the court, Atiku Abubakar on October the 6th filed new documents seeking the Supreme Court's nod to present a deposition on oath of the registrar of the Chicago State University concerning President Tinubu's academic records. Mr. Abubakar is questioning the authenticity of the president's academic certificate submitted to INEC, alleging forgery of the document, and seeking that he be disqualified and removed from office. The Labour Party and its presidential candidate on their part filed a 73-page notice of appeal. The document, which was filed by 13 senior advocates and 25 other lawyers, was anchored on 51 grounds. Among other arguments, Mr. Obi and the Labour Party said the Presidential Election Petitions Court erred in law and reached a wrong conclusion when it dismissed the petition he lodged to challenge the outcome of the presidential election. He maintains that the lower court carried out a miscarriage of justice against him when it held that he did not specify polling units where irregularities occurred during the election. Mr. Obi also accused the panel of erring in law and striking out paragraphs of his petition, dismissing his witness as incompetent, a situation which he says breached his right to fair hearing. The APM, on its part, has insisted that President Tinubu contested the presidential election without a lawful running mate. The party said that the withdrawal of Ibrahim Masari and the expiry of the 14 days permissible for changing or withdrawing candidates under Section 33 of the Electoral Act 2022 made President Tinubu's election and return invalid. There's been lots of speculations as to the composition of the panel to hear the appeal, and all eyes are on the Supreme Court to do justice in the three appeals before it.
Welcome back. Yes, indeed, that's is part of what we'll be focusing on today. We've got Mr. Ikazo Akariwe, Senior Advocate of Nigeria, here with us. He is a former first Vice President of the NBA and convener Lead the People. Good morning. Thank you for coming.
Good morning. Nice to be here again.
Well, first of all, the Justice Datijo bowing out of the Supreme Court, is that going to affect anything? I know that lawyers, justices had complained that they were short. They were under huge pressure. In fact, last week, I think it was in the House of Reps, but it was the National Assembly, where they were trying to make a case that the president should appoint 3 more justices because the ones there are under huge pressure. So now, with him bowing out, what's the implication of that?
Yes, the Constitution makes provision for 21 justices of the Supreme Court. And with his leaving on Friday this week, they're down to perhaps 10 of them. Like I said when I was here the last time, nobody understands why people who left the Supreme Court 3 years ago have not been replaced. Justice Unguta, who died 2 years ago, has not been replaced. Justice Oseji, who died like 2 years. In fact, Unguta is probably about 3 years now, or 2.5 years. Oseji, who died 2 years ago this month, has not been replaced. What is going on? So you now have a situation where you appoint 11 on one day, and those 11 do not have the opportunity of understudying before they become heads of the panels. So if you appointed somebody to replace Unguta 3 years ago, the person would have had 3 years experience now at the apex court. So the 10 who are there, and remember that in Nigeria, the Constitution allows virtually everybody to appeal. Unlike in the US, where it's only by judicial review. Not every case goes to the Supreme Court. So the Supreme Court has hundreds of cases, thousands every year. They're coming in. The other day we were at the Supreme Court, we got a date for 2025. What? 2025. I mean, well, there is a saying, justice
even
delayed.
Some visas are not that.
But it's not the fault of the justices. They can only do so much and no more. The 21 can't even cope. So there is something wrong with overworking the justices of the Supreme Court. There's no time to even meditate on the cases and create a philosophical basis for your decisions. There's so much on you which you must adjudicate upon, and you have a time frame. The NJC has given you a time frame within which you have to deliver the judgments. So we are suffering a wholesale failure in justice delivery, not because of the incompetence of the justices.
Wholesale but because failure.
Yes, because of delays. And the delays are due in parts to two things: the depleted number of justices, but even more importantly, the constitutional allowance that everybody can come to the Supreme Court. So a tenant could actually take his landlord through the magistrate's court to the Supreme Court in 15 or 20 years or 25 years if he can afford it. We need to amend that aspect of the Constitution.
I was even going to go there.
Yes, thank you.
Is it out of place for the NBA to pick on these kind of issues and say, look, the country, we need to move forward. Hence, we're proposing this and this kind of amendments and see how they can push it through.
It's not out of place at all.
How come we haven't, unless I'm missing something, I've not seen or heard it?
Well, the NBA has been engaged in advocacy, but I'll be the first to say that the NBA can do more. We should be able to do more. We should really take this. I mean, our presidents have spoken about this, but I think we've come to the point where we need to not just speak about it, to engage the National Assembly on things like this. NBA should be doing more. I concede.
You're going to make a second point in terms of what?
Yes, well, I was going to say the Constitution needs amendment. Everybody can't come to the Supreme Court for any and every issue. I think that where we are now, we need to have regional, if you like, geopolitical courts of appeal or Supreme Courts, which will take a certain level of cases. I don't know what a land case emanating from the culture and customs of Nnewi is coming up to the Supreme Court for. So we should have a system where the Supreme Court should be circumscribed to constitutional issues and perhaps any other issue which would create a change in our judicial system or jurisprudence. And by that I mean the Supreme Court should decide what cases they want to hear. Okay, the case law says that there are 5 ways of proving your title to land. For example, 5 ways of proving your title to land. Somebody goes to the High Court and he loses. The High Court says, you have not proved your 5 ways. You didn't prove any of them. Then he appeals to the Court of Appeal. Court of Appeal says the same thing. What is he doing in the Supreme Court? Is it likely that the Supreme Court is going to say, oh, you proved one way, actually, and the 2 lower courts made a mistake? Most unlikely. So some cases should not go up there.
Even when cases are in Supreme Court, we hear and read, they say, no, they're going back to the Supreme Court to interpret their own judgment.
Yes.
And you just wonder. But, yeah, you're going to... I'm just wondering because now, if I could move into...
Matter at hand today.
Yeah, even though cautiously as well. So
Yes.
we're not going to be discussing what the priors before the court, so we'll not do that. But you already know how the hoopla about the last decision, the judgment, and what lots of people, how, of course, you know, those who lost usually will not be happy about this. And then there's a build-up to this particular scenario today now. Right. Yes, they're beginning to hear the case. So in light of the kind of impression people have out there, what to expect, how this case should go, and I just wonder your impression about, is it that what you have heard and read, do we understand what the issues are? Are we overtly optimistic for those who are, and then those who think, no, don't worry, the Supreme Court can't do, there's already something established here. All of that expectation.
Yes.
Help us interpret that in the light of how the court works.
Yes. Let me first of all say that I'm going to be as circumspect as you have been because of the principle of sub judice. Sub judice means under judicial consideration, therefore not open to public discussion. So since these issues are under judicial consideration, I'm going to be really very careful. Now, then, to go to the main issue, Nigerians have been very unfair to the justices. They have. But I also understand why. The reason is because many Nigerians don't understand the way the court works and do not understand the mind of the court, the thinking of the court. The reason a court will reason the way it would. You know, all the justices at various levels have been tarred with a brush of perhaps iniquity. It's not fair. It's not fair. I wish I could give a real-life example, but the matters are now in the Supreme Court. But if I will attempt to give a real-life example, no, I can't. I simply can't. But if I were to condescend upon the particulars of some of the things the court pronounced upon, the Court of Appeal sitting as a tribunal, if I were to explain the reasoning, we see that their hands were tied not by man, but by the law and by the way things are, and by the lawyering. You see, when
I was going to go there.
Yes, when lawyers bloodshed and trouble. So if the people must not be allowed to go to the streets, let them be encouraged to come to the courts. It's better for everybody. And when you swear in the governor or the senator or the president, and the case is still in court, justice must not only be done, but be seen to be done. So everybody feels, wow, he's already there, the commander-in-chief. He's there, he's the governor. And the case is in court. No, he just make a phone call and intimidate the justices, even if he won't do that. It seems to me as if elections should be like 6 months earlier. And let the outgoing incumbents, or well, if he's still the incumbent and it was a re-election, let him just be there. He'll be a lame duck at that stage, but the cases should be fully
Can
litigated.
he really be a lame duck?
Well,
sitting on that seat?
Well, yes, I guess so. But somebody who is on the way out, or potentially on the way out, will be said to be, in some sense, a lame duck. I see the point of your observation. So we certainly need to have the cases fully ventilated. First tribunal of first instance to the Supreme Court before anybody is sworn in. It's better for even the perception. So that lawmaker is on firm ground.
All right. I think we should go to a break, but we'll be back. There's still a lot of grounds to cover. Don't forget, we're keeping tabs as well on the courts. What is going on there? So if you want to be a fly on the wall, just might have one for you. So stay on with us.
Thank you for staying with us. We still have Mr. Ikazo Akariwe, who is with us in Abuja studio. He is a senior advocate of Nigeria. Allow me to piggyback on what Maokwe asked you the other time about having all of the issues resolved before the fellow is sworn in. We featured a lawyer yesterday who suggested something perhaps even a little more extreme, if I can say. He suggested that we should have all issues, all pre-election issues resolved even before the elections, particularly because, one, according to him, we have 4 years between elections, and secondly, that's something that's already been practiced in the US. He suggested that, look, if we're able to resolve all pre-election matters before elections, those things are settled well in advance. He even cited the issue of Mr. Donald Trump, who became president at some point, and then there were more than 100, I think you said more than 200 cases before the election, all resolved before the election. What's your take on that?
All pre-election issues resolved before the election. That seems to me to be a tough sell. I can understand all elections emanating howsoever from the elections being resolved before swearing in. But pre-election issues resolved before the elections, that's hearing it for the first time. I guess it is doable, but let me quickly observe to us that the justice delivery system is suffering from electoral matters. You have to suspend all your cases, not all, but quite a significant proportion of cases suspended to enable judges leave their regular beats to go and hear these cases. But the solution is not rocket science. The judges are too few. Even discounting electoral matters, the judges are too few. There is no state in Nigeria today which should have less than 100 judges. High court judges and not less than 200 magistrates. If we will stop paying lip service to effective dispensation of justice. But when I say 100 judges, I mean 100 highly qualified legal practitioners who have practiced law and so can hold their own on the bench. So if we increase exponentially the number of judges, if the Federal High Court, which is saddled with the jurisdiction over pre-election matters, the Federal High Court would have no less than 300 judges. Why not? But if you are going to just have 50-something Federal High Court judges, 70 Federal High Court judges, already overworked with dockets of about 400 to 500 matters, and then you're going to now saddle them with pre-election matters which must be finished before the elections, we're going to really have a very difficult situation on our hands. So it's doable, but for us to resolve the matter of electoral disputes in court, and not just electoral disputes, but for us to resolve them, we need to exponentially increase the number of judges of our courts.
Okay. Well, let me ask you a we the people question, if I may. You began the other time by talking about the reaction of people to some judgments that come across to them because they just don't understand how it works. So it leads me to question again how much education people have about judgments, proceedings, and all those things. So help us understand the quantum or otherwise of the knowledge of the law, the legality of the law, and the morality of the law that come from these cases, whether our people understand it or not? And what should people understand when it doesn't sound like what they think is right?
I have thought long and hard about this. When I hear the commentaries of the public about judgments of court, and when I realize that the commentaries are off the mark, I now realize that the courts need to create and staff a robust public relations department. The Supreme Court has a public relations department, for example. My friend, Dr. Festus Akonde, a good man and effective public relations practitioner, chairs that department. But having said that, I realize that that department needs to be enlarged and needs to expand its scope by engaging on a daily basis issues that are coming up in social media. Nigeria is a democracy now, and Nigerians are politically alive and active. So should there not be now a necessity for, let us explain this judgment? Every time there is a judgment of public interest and contention, perhaps a department needs to break it down. This was the raison d'etre for the decision. This is why it happened. And not only break it down in English language, but in as many languages as our electronic media are today covering, so that the masses are entitled to know, so that the masses can be educated. Because this wholesale accusation, every time a party loses a case, is because the judges were bribed. And educated Nigerians say it. And we who are in practice, we know that it is not so. That is not to say that we've not had a few cases of judges who did not abide by their oath of office. But I can tell you for free that the wholesale demonization of the justice sector is unfair and untrue. And, you know, the justice sector is in danger. It's in danger of being capsized by the public misunderstanding and misperception. Again, judges are human. Judges can make mistakes, which is why we have the High Court, and you can appeal from High Court to Court of Appeal, and from Court of Appeal to the Supreme Court. You can appeal from the Magistrates Court to the High Court. And then, wherever 2 or 3 lawyers are gathered, there's a difference in opinion.
Okay.
So there are so many opinions.
Yeah. Let me ask you this.
The judges, by and large, they do their best.
Well, let me ask you this one, because our correspondent is standing by. But let me just ask you this one question. A good number of people, of course, the political parties, all the people who are making their cases, are hoping that one way or the other, whatever it is that they have, they're going to have a fair hearing and get justice. But one of the issues that I'm pretty sure you are aware is making the rounds is whether or not any evidence is admissible now, or are they statute barred? Just an education, no, nothing complicit. There are those who have said that, look, no evidence can be admitted by the Supreme Court. Yes, some evidences can be admitted based on one thing or the other. Just help us understand. So that we, the people who are not as learned in law as you, can understand why or what the basis of some of these things are. If it is too risky, just let us know.
Yes, it seems to me, it does seem to me that the issue you have just asked me to pronounce upon, to speak to, is one of the issues the Supreme Court will be looking at. I think the the petition, the appeals of the PDP were all over social media, and I have looked at them. Sub judice. Sub judice means under judicial consideration and therefore prohibited from public discussion.
Oh dear.
I appeal to you, my good friends, let's leave that. The Supreme Court is going to, they have up to November 5, I think, up to November 5. So in less than 2 weeks. It might even be this week. You never can say, because they have up to November 5. So after November 5, we will come here and we're going to ventilate our different views on the matter.
Let's just have a sneak peek on what to expect today. So we've got our correspondent, Ella, who is there, excuse me, covering the courts. So, Ella, good morning to you. So what is going on where you are at the moment? Are they all gathering? Is everything set? What's the mood right now in the courts?
Good morning, Chamberlain. I can tell you that the Supreme Court here is a beehive of activities. A journey that started in March is finally here at the Supreme Court for the final lap on the victory of President Tinubu. As you can see behind me, you can see security agencies. They have practically taken over the place from the DSS, and at the gate we have the police, just like how we had at the tribunal some months back. So right now, people are just waiting to see how they could enter into the courts and go through the checks to see how they could get their names. Some have not been allowed to enter, especially the cameramen, but there's a back and forth on how to ensure that they can come in to take some shots. And then what we're expecting today is going to be a long, long sitting, because we have the appeals from the PDP, the Labour Party, and the APM, who are challenging the judgment of the tribunal. That's the Presidential Election Tribunal, which had declared President Tinubu as president. And also, there's also the motion by the vice president, the former vice president and the presidential candidate of the PDP, who is asking that the court should admit the documents from the Chicago State University as fresh evidence in the sitting. But if you can remember, the lawyers to Tinubu had said that that can't be possible because it was not admitted at the instance at the tribunal. So, and they have passed the appeals here at the Supreme Court, I beg your pardon. So it's not possible for them to admit such documents today. And all that is there's going to be a lot of back and forth from the respondents, as the INEC and President Tinubu and the APC. They're also going to state relevant laws on why such documents, as the fresh evidence by Vice President Atiku Abubakar, former Vice President, I beg your pardon, should not be admitted as fresh evidence today in court. So it's going to be a long sitting today. We expect to be here for a while. And then probably after the hearings and the counter arguments, a date may be reserved for judgment, or if it's like in the past, I've seen in the past, judgment may be delivered today. It's not far from possible, and then a date to be reserved for reasons that's happened in the past, and we expect that may also happen today. That's under probability, or they will just fix a date to come back for judgment. Chamberlain.
Promises to be very interesting, but could you tell us, what about the APM? Many wonder, what are they seeking?
Sorry, could you come again?
The APM, what about their case? Well, what exactly are they asking for?
Just like they had at the tribunal, if you remember, they're also saying that the Vice President Shetima had double nomination. So they're still standing on that ground. And even though the Presidential Tribunal had struck it out, they still brought the same appeal here. That is one of the appeals that will be heard from the APM this morning.
Now, about the coverage, you know, the last time it wasn't clear whether or not media was going to be allowed to cover it because they had moved it. And then after a while, it was concluded that no, that wasn't going to happen. But somehow, almost at the last minute, then that notice came and then saying, look, okay, yes, that can happen. So in this case, is it a similar scenario, or have they flatly said, look, no media, no cameras inside the court? You can't even just face the lawyers and back the judges. No such thing this time.
Absolutely not, I can tell you this morning, because right now the cameramen are even outside the court. They have not been allowed to even go in to even take the usual shots and take the usual shots as is usually done. So right now, to even live coverage is way out of it.
Oh boy, dashes our hopes. I don't know if Ayo was expecting something. Ayo, nothing for you.
Well, I wasn't even expecting that one because I think we've heard from a number of lawyers about that and how it puts the judges or justices at risk. But, Ella, what I would want to ask, I mean, you've talked about the fact that there's been some layers of security in the perimeter. Any sighting of supporters of any of the those who are adjudicating in the courts, any supporters of whatever political party or individual around the courts, are they allowed anywhere near?
From here, that's right outside the courtroom, not within the premises, and I don't think they'll be allowed to come into the courtroom. Those who are just in are those who have their names on the list from the Supreme Court.
Now, any expectations? Any expectations of you? I mean, from your experience, you know, covering this bit, what's unique in this one, or is it just another one?
Please, could you come again?
I said, from your experience, Ella, covering the judiciary, is there anything unique or peculiar about this particular one, or is it just another one?
I dare say it's just like every other sitting that we've covered. It's the same arguments year in, year out, but we never can tell. This year may be different, but the words on the street from everybody might feel that it's the same judgment. They're going to uphold the judgment from the tribunal, but that's just the word on the street. We could expect something different from the 7-man justices that will sit from 9 a.m.
Most certainly expecting that you give us more, you know, as things unfold. Thank you so much, and all the best, and please keep safe. I want you for that. But let me ask you, Sakariwe, back to you now. I was trying to get information about how much understanding people have about the legality or the morality of the law, whatever it is that is presented at the end of the day.
Yes. Let me just say something emanating from that sound bite. You asked if the press were going to be allowed into the court, if there's going to be live coverage of the proceedings. I think that is one way to go. We need to demystify the courtroom. We need to make plain as we can the proceedings of court and what goes on in there. And I am yet unable to understand why the cameramen are not allowed into the court. For a high-profile case like this one, and like when it was before the tribunal, I think that the Supreme Court should even have her own cameras, the Court of Appeal to have her own cameras, which will be filming the courtroom proceedings, and then the various networks will syndicate with them and collect the videos, and then play it or transmit it to their viewers. It will help to some extent to demystify the courtroom and enlarge understanding of what goes on in there. Many people were upset. I read that on social media. You refused to allow us watch the proceedings. Then you transmitted live the judgment. Why did you transmit the judgment? And you know it was such a boring thing. You know, but where the fireworks was ongoing, the arguments, the objections, and the examination of witnesses, they were not transmitted live. Then you decide to, what was the rationale behind now deciding to transmit the judgment, people reading for 12 hours and lawyers sleeping off in court and so on? All that was now in the public domain.
Not just lawyers, even us.
Even the president.
I was there too.
I saw one of your
found out.
Yes, I didn't see you, but I saw one of your famous people.
I dodged the cameras. I was fogged up.
Yes, so there was need to have really done the proceedings, transmit the proceedings live. And I think that's where we are being too conservative, if you ask me.
It'll be interesting to see if that will be adopted eventually. But I was going to ask you if you think that the presidential matter, because I think almost every single presidential matter, maybe aside from the very first one in 2015, yeah, that's one that didn't go to court at all. And the circumstances were very, interesting. But then in 1999, after the first elections for the dawn of the Fourth Republic was conducted, the major rival in that particular election went to court, and I think he only stopped at the initial presidential election petition tribunal. He didn't go further. Apart from these two,
Olufalaye.
Yes, Olufalaye. Almost every other case has gotten up to the Supreme Court, and it seems that nothing is resolved or nothing is accepted as final until it is at the Supreme Court. We've already done some amendments now in such a way that for the presidential elections, there are only two courts. The Court of Appeal serving as initial presidential election petition tribunal, and then the Supreme Court. Do you think we should just have the Supreme Court intervene once and for all in the presidential election petition tribunal?
I'd rather we follow the current system. Because if the Supreme Court it becomes the first and the last arbiter, that means Supreme Court will have to take evidence. Not that the Supreme Court cannot take evidence in certain situations. The Supreme Court is empowered to act as a court of first instance, but it is better for the perception of justice that 5 justices sat down and heard the case, and then if you were not satisfied, you went up before a further 7. So a total of 12 justices have heard your case. I would rather that the Supreme Court maintains its position as a purely appellate court in such a situation.
Okay, it'll be interesting to see how that eventually pans out. But if we're also looking to speed up processes ahead of, swearing in of candidates, some people will say maybe that's the way we should go, and that's what some countries have done.
I see. Well, we can still speed up. We can give 6 months. 6 months for the entire litigation system. Let litigation take place in 6 months, and
will it be enough
after that? It can be enough. Nobody thought this 180 days would be enough, because once upon a time we were in tribunals for 3 years. The Ngige case in Anambra State, for example. But I think that one area we need to explore, if we will reduce litigation, we need to introduce proportional
representation.
Yes.
That's parliamentary style, isn't it?
Yes.
We can bring in, do we switch to parliamentary? Is that what you're asking?
Not really. Even within our system now, you see, the winner takes all situation is what is spawning a lot of litigation. If now the person who wins the president, like I think it was about 40% or so that the president got, if he gets that, if he wins that, and then the House of Assembly, the National Assembly, it just represents the percentage he got.
So that be coalition government.
Then the PDP got like 6.9 million or so. The PDP has a number of assemblymen proportional to the votes a candidate got. Yeah. Labour also. Litigation will drop because, okay, we didn't win, but we have a fair number of persons in government. So we'll now find that a coalition system of government will begin to arise. Because it will drop litigation.
They spend a lot of money in litigation, as a matter of fact. We understand that to see...
But if you think litigation is expensive, try rioting and bloodshed and the alternative to litigation.
Civilized warfare
litigation is civilized warfare, yes.
All right,
better to jaw in court than to war on the streets. Let me paraphrase Winston Churchill.
All right, Mr. Akariwe is a senior advocate of Nigeria, former first vice president of the NBA and convener of We the People. But next we'll talk about You know, those recommendations about reforming the electoral process, you know, part of the issues there, transmission of results electronically, part of that as well, ending cases before time. How will these fly? That's part of what we'll be focusing on next, so don't go.